Hello and welcome to the next instalment of Ask a Silk from Outer Temple Chambers. This week we are asking a not silk, but part of the same series, a very interesting case which we thought was worth being talked about. And so we are discussing the implications of the Court of Appeal's judgment in A and C from 2020, a decision on the jurisdiction of the English courts to make orders in support of foreign arbitration proceedings. I'm speaking to Teresa Rosen Peacocke, who represented the successful appellant in the Court of Appeal. Teresa is a member of Chambers' international commercial law team. She's dual qualified, English barrister and a New York attorney. Whereabouts in the world are you at the moment, Teresa?
I'm in London, Stephen, as I have been since the hearing in the Court of Appeal in this case, almost exactly a year ago. I flew to New York for this hearing in March 2020 and expected to remain for a short time to assist in the deposition if the appeal was allowed. In the event, however, the lockdown, we had an in-person hearing in the Court of Appeal, but the lockdown was imposed almost immediately after that. And my flight back to New York was canceled. The deposition did take place very shortly after the Court of Appeal handed down its decision, but under lockdown conditions, which created their very own special logistical problems. I'll leave that, however, for the topic for another day.
Well, this case is the sort of thing that you in particular are very familiar, but other people at Chambers familiar with, working with English and foreign domiciled clients in litigation, arbitration abroad, and helping them to make use of the English courts to support those foreign proceedings. The Court of Appeal's anonymised decision came out just before the first lockdown in England, and it deals with the long-standing controversy over whether orders of the English court under Section 44 of the Arbitration Act 1996 can be made against non-parties to arbitral proceedings. The fundamental importance of the Court of Appeal's decision, as many people well know, is that the absolute barrier, which some people said existed, to orders against third parties, certainly that was what other first instance decisions had said, that barrier has now been removed. And so clearly a helpful development for the international arbitration community. And that's what we're going to be talking about. So let's start with the facts of the case, Teresa. Obviously, you know about those very intimately. What was it about?
What was the case about? The underlying dispute in A against C was being arbitrated in New York in a very long standing arbitration concerning the enforcement of agreements between joint venturers in the exploration and development of an oil field in Central Asia. My clients, the appellants, were the claimants in this arbitration. They were seeking payment under these agreements from the first and second respondents, who were the defendant oil companies in the arbitration. My clients were entitled to a percentage of the net proceeds of the 2002 sale by the oil companies of their interests in the oil field. The defendants sought to deduct from the sale proceeds substantial payments that they had made to the Central Asian government, described as signature bonuses. My clients contended that the sums paid were bribes and were not properly deductible. The principal negotiator for the Central Asian government had been indicted by the US court for violations of the US Foreign Corrupt Practices Act. The oil companies sought to rebut the allegations of bribery, relying on evidence from one of their legal representatives who'd been involved in negotiating and drafting terms for the joint venture. My clients sought evidence from the third respondent in the appeal, now living in England, who had been the lead commercial negotiator for the oil companies, and in that capacity had negotiated the signature bonus payments directly with the government's allegedly corrupt negotiator. The third respondent was approached, but was reluctant to give evidence at the behest of the opponents of his former bosses, and refused to agree to be deposed by the appellants. His reluctance was, not surprisingly, encouraged by the oil companies.
Not a huge surprise, I think we can safely say. So you were faced with, or your client was faced with, star witness hiding somewhere in England. What were you able to, or did you try to ask the court to do about it?
We made an application under Section 44(2)A of the Arbitration Act, 1996, which expressly provides for the court, in aid of arbitration proceedings anywhere in the world, to make orders for the taking of evidence of witnesses. It's not at all controversial that the English court does have power to order deposition evidence under CPR Part 34.8. The real issue was whether that power was limited under Section 44 of the 1996 Act to obtaining evidence from a party to the arbitration. The application was argued at first instance by me, came on before Mr. Justice Foxton, and as another little tweak, interesting tweak in this case, it was listed within days of Mr. Justice Foxton being appointed to the commercial bench in January 2020. He found, in his words, considerable force in the argument that Section 44 powers could, in an appropriate case, be exercised against a non-party to the arbitration proceedings, but he concluded that he was bound to follow first instance decisions, in particular a decision of Mr. Justice Males, as he then was, in a case called Cruise City 1 Mauritius Holdings against Unitech Limited in 2014, and a following decision by Sarah Cockrell QC, as she then was, in DTech Trading and Morozov in 2017. Cruise City was a case involving an attempt to serve out of the jurisdiction an application under, amongst other things, Section 44(2)E of the 1996 Act, providing for the court to make injunctions in support of arbitration proceedings. The applicant sought in that case a freezing injunction by way of Shabra relief against non-parties to the arbitration agreement in aid of their enforcement of an arbitration award. The targets of this application were located abroad, and so in addition to making their application under the 96 Act, they also needed permission to serve that application out of the jurisdiction. Mr. Justice Males held in that case that Section 44 was not available to third parties to an arbitration agreement. For similar reasons, in 2017, the claimant in DTech was unsuccessful before Sarah Cockrell QC in obtaining an evidence preservation and inspection order against foreign-based third parties under Section 44(1)B of the 1996 Act. In both cases, the applicants needed permission to serve their claim forms out of the jurisdiction. In those cases, the judges had been strongly influenced by the consensual nature of arbitration and the fundamental assumption that agreement-based resolution mechanisms should be binding only on the parties to that agreement. As a result, despite the fact that different subsections of Section 44(2) were in play, in both Cruise City and DTech, the judges had construed Section 44 as a whole as permitting only inter-parties orders. Mr. Justice Foxton followed those cases, but gave my clients permission to appeal, saying that the arguments in favor of non-party orders were formidable, and if there had been no prior authority, he would have been inclined to accept them. He also recognized the importance of the issue to the arbitration community, expressly mentioning the impact on the court's powers to grant Shabra injunctions in the arbitration context.
You not got the answer you wanted at first instance, but you had got a pretty clear indication and permission to appeal to the Court of Appeal. As is common, presumably, in these sorts of cross-border cases, it's normally an issue. you've got a clock still ticking somewhere else in the underlying arbitration proceedings, but you still haven't got your clear evidence.
Absolutely.
What do you do about that?
Well, we actually got more than we expected at first instance in terms of favorable comments, particularly in relation to the granting of the appeal. The Court of Appeal also recognized the importance of the issue and the time-sensitive nature of the appellant's application. And they listed the full hearing of the appeal before a very strong court comprising Lord Justices Flo, Males, and Newey in early March 2020. So they moved very, very promptly in light of the fact that we made it very plain to them that unless we could obtain provision for deposition evidence in accordance with the scheduling of the arbitrators, there'd be no reason to pursue the appeal.
What do they decide? The
Court of Appeal allowed the appeal. They professed to adopt what they called the narrow approach of considering only whether Section 44(2)A permitted the English court to make an order for the taking of the evidence of a non-party witness without embarking, they said, on the question of whether Crewe City or DTEC had been correctly decided. However, and quite inevitably, the court's reasoning extended to the consideration of the true construction of Section 44 as a whole. And in his lead judgment, Lord Justice Flo addressed and rejected the entirety of the reasoning of Males in Crewe City as to the operation, the construction and operation of Section 44, which also had been expressly adopted by Sarah Cockerell in DTEC. In this way, the Court of Appeal decision cannot be said to be squarely limited to Section 44(2)A and the taking of evidence of witnesses, without being seen as undermining the force of any argument based on prior authority, based on the general construction of Section 44, that should be construed as limited to powers exercisable only between parties to the arbitration.
And so you've said that the reasoning, which is the reason we're interested in the case, really, the reasoning can be applied broader than just the specific subsection dealing with deposition evidence. But I suppose the key question is, what was the reasoning?
Well, the most important reason for the view adopted by Lord Justice Flo in his lead judgment was, he said, the natural reading of Section 44(2) in the context of the 1996 Act as a whole, including Section 2(3), which expressly stated that the powers under Section 44 should be exercisable in relation to arbitration seated anywhere in the world. The court was expressly given, quote, the same powers in relation to arbitration as they have in civil proceedings. It was pretty straightforward language under Section 44. Lord Justice Flo rejected all of the respondents' arguments based on the judgment of Males in Crewe City as to why Section 44 should be limited to the parties to the arbitration agreement. In particular, he construed the procedural elements of Section 44, such as requiring the consent of the opposite parties to the arbitration, or the permission of the tribunal in order to launch an application under Section 44, and the powers being exercisable only in circumstances in which the arbitrators didn't also have power to act. They construed those procedural elements of Section 44 as simply thresholds or gateways which have to be satisfied before the court can exercise its powers, rather than considering those provisions as indications of the scope of the provisions of Section 44 as Males had done in Crewe City. The only opposing point that Lord Justice Flo considered had some force was the restriction in Section 44(7) that appeals from a decision under Section 44 required the permission of the first instance judge, thereby precluding the refusal of permission at first instance and permitting a prospective appellant seeking permission from the Court of Appeal directly. But notwithstanding that limitation, which was said to be very unfair to any third party who was the subject of an order under Section 44, he considered that this was more of a theoretical problem than real, because, he said, the first instance judge was likely to grant permission whenever, as in this case, there was an issue of principle at stake.
I guess the question everyone is asking in discussing the case is a one you touched upon already, but how far does the decision go? What, in your view, can we say now about the jurisdiction of the English court in respect of foreign arbitrations?
Well, unsurprisingly, given the composition of the Court of Appeal, which of course included the now elevated Lord Justice Mayles, whose decision in Crewe City was being challenged by the appellants, the Court of Appeal did try a tactful approach to leave open the question of whether Crewe City and DTEC were correctly decided, and thus whether the other subsections of Section 44 might be construed differently from Section 44(2)(a). But at the same time, in order to address the reasoning of Crewe City and DTEC, Lord Justice Flo had to consider the proper construction of Section 44 as a whole, as had happened in those cases. And he did so, and he rejected all of the reasons given for saying that Section 44 should be limited to inter partes orders. So the attempt, in my view, the attempt at tactfulness essentially failed in light of the way in which the judges had to approach the question of the operation of Section 44(2)(a). Even Lord Justice Mayles, as he was by then, appeared to acknowledge this point by noting in his concurring judgment that his prior reasoning in Crewe City had been expressed as, quote, equally applicable to all of the different paragraphs in Section 44(2) without distinguishing between them. In other words, he acknowledged that he had addressed the operation of the provision before him as a matter of the proper construction of Section 44 as a whole. In light of the decision of the Court of Appeal in A against C, it's now, in my view, unrealistic to argue that any subsection of Section 44(2) excludes non-party orders as a matter of construction or prior authority. Further, looking at the language of all the subsections of Section 44, there's nothing in them to suggest that they should be limited to inter partes orders, particularly if the theoretical concerns over party-driven and consensual operation of the arbitral process falls away. The Court of Appeal acknowledged that their decision would create what they called a somewhat anomalous situation in which an English court can give an order requiring a deposition in support of a foreign arbitration when the same relief was not available in support of foreign court proceedings by virtue of the operation of the Hague Convention and the Evidence Proceedings in Foreign Jurisdictions Act 1975. This was pressed very hard by the respondents in the appeal, but the Court of Appeal nevertheless held that this didn't justify effectively nullifying the operation of Section 44 as applying only to arbitral parties. The court rejected the third respondent's arguments that the court has and should only ever have very limited powers to order evidence for foreign proceedings, but instead took a common sense approach to the purpose of and the reality of arbitration proceedings. Even Lord Justice Mayles noted that in modern arbitrations, a witness is rarely an arbitral party, and he appeared to be willing to see arbitration proceedings in their particular context, in which the complex machinations of state-to-state treaties, such as the Hague Convention, are simply not applicable. And in his words, rough edges may be tolerated.
Takes us a bit of crystal ball gazing. What sort of use do you see the principle, talking about the general principle of construction there, being put to by parties now? What sort of applications do you anticipate being made?
Well, the impact of A against C has already been felt in the US and in the UK, although in my experience, a lot of cross-border activity has been drastically curtailed during the pandemic. I've already advised on evidence and procedure in subsequent cases of arbitral parties seeking to obtain deposition evidence. And I understand that in at least one case, the matter was resolved by consent. The opposing party seemingly appreciating the risk of an adverse cost order in the UK. This is something that has huge impact on the minds of attorneys operating in the US that find themselves involved in any sort of contentious proceedings over here. This aligns with my experience under the 1975 Act for obtaining evidence for US litigation. The permissive gateway of obtaining evidence has a real impact on the attitude adopted by opposing parties. The more interesting and probably most important question arising as a result of the decision in A against C involves the operation of Section 44(2)(e), which is the power to make injunctive orders, especially Mareva and Shabra orders against third parties in arbitration proceedings or by way of enforcement of an arbitral award. The indication is that that would be the most important use of the powers under Section 44. And it certainly appears to me that there is now a gateway to relief in those respects. But on the other hand, it has to be said that there remains some not inconsiderable judicial opposition to the A&C decision and its operation. There was a panel last year that included Lord Justice Flo and Lady Justice Cockerell as part of the, I think it was the anniversary of the commercial court. And they discussed the decision in A against C. There was no doubt at all that Lady Justice Cockerell stands by her decision in DTEC and the reasoning of males in Crew City and considers that A&C was wrongly decided. So there's now clearly a gateway, a prospect of Section 44 relief against third parties, but this is not to say that the road to relief is entirely smooth.
Very interesting. Thank you for taking the time to explain it to us and to anybody who's watching. A really interesting judgment, and as you say, most interesting to see what follows from it. And hopefully some people at least won't be dealing with it by consent for the sake of everybody else who's watching. Otherwise we won't know what everybody else really thinks the answer is.
Absolutely.
Hope that at some stage, if you want to, you do manage to leave the country and get back to your other place. But thank you, and thank you for watching the latest Ask a Silk.
Stephen, thank you very much for inviting me. It's been a pleasure.